The actual real act, the Title IVe plan, says court orders that reference state or tribal law to substantiate judicial determinations are not acceptable. You can't put in your statute and say, therefore, we can take the kid because the statute says so. There must be a judicial determination. What does judicial determination mean? Watch this. Well, you can't do it if you got a contract with the states. We're going to look at the parties involved. Title 42, 674, cooperative agreements. They got people involved by contract, which is different from a judicial determination. This is a private business getting together, lying to take your kid. Watch. This is talking about who they're going to give money to in the cooperative agreements. Short-term training of current, prospective foster or adoptive parents or relative guardians, the members of staff of state licensed or state-approved child care institutions or state licensed or state-approved child welfare agencies, providing services. They're businesses that provide services. This ain't no judicial court. To children receiving assistance under this part and members of the staff of abuse and neglect courts. Wait, y'all got contracts with the abuse and neglect court? Well, that's not a judicial court, because you can't pay the judicial court to work on your behalf and partner with you and still be judicial. Agencies, attorneys. Yes, the district, not the district attorney, but the attorney general's office. They're under contract too. That's why when you go to Attorney General and you try to tell on CPS, they can't do anything because they work for CPS. They're under the same darn contract. Watch this. Attorneys representing children or parents. So the dang attorney they give you is under contract with Title IVe. The one they give to your child, under Title IVe. Guardian ad litem, they're under Title IVe. Everybody's working business together. Or other court-appointed special advocates representing children in such proceeding of such courts. Okay? So they're all dealing with private contracts, guys. That's all they're doing. But they're getting us because they get us to believe that it's a judicial termination. Watch this. 45 CFR 1356.21. Payments, programs, implementation requirements. Now, what we're going to see is these people are running game. They're running game. Watch this. In order to take the child, in order to start this process up, judicial determination must be made. That means a court tried you by a jury of your freaking peers and said you did something wrong. If not, and they have not charged you, these people are fraudulently tricking you to come into their so-called courts to do business. Watch this. If the determination of reasonable efforts to prevent removal is not made as specified in paragraph B1 of this section, the child is not eligible under Title IVe for maintenance payment program of that state in foster care. Judicial determination of reasonable efforts. There must be a judicial determination. Remember I showed you guys where they said that the administrative law characters will try to take away the judicial determinations or the power of the judiciary. The Title IVe agency must obtain a judicial determination, okay? But these agencies are not providing judicial determinations. They have to charge you and convict you to prove that you are not capable of taking care of your little ones, and they're not doing that. Family are not required if the Title IV agency obtains a judicial determination. Watch this. A court of competent jurisdiction has determined the parent has subjected the child to aggravated circumstances. Now, we know in the federal law what that means. Watch this. Let's see what it means. Murder. Okay? If the offense had occurred in special maritime or territorial jurisdiction of the United States of another child of the parent, you had to kill one of the kids. Voluntary manslaughter, you had to get charged or convicted with this. Aiding or abetting, attempting, conspiring, soliciting to commit murder or such a voluntary manslaughter. This is what they're supposed to use. And this wasn't for people to just come take your kids from you because they had concerns that your dishes weren't clean. This was if somebody killed somebody, got convicted, you killed your spouse, got convicted, so the kid had to go into care because a judge in a judicial court said you were guilty. Watch this. A felony assault that results in serious bodily injury to the child or another of the parent. So that means that you had to get in trouble for committing some crime, hurting somebody, killing somebody, get prosecuted before you freaking before they freaking remove a child from your darn home. So these people have tricked us to believe that the CPS court can just write a permission slip saying, hey, we're going to just go ahead and remove your kids from you because we're God, and therefore everything is going to be okay. Now let's look at the due process protections, because this is about an abuse and neglect course. Notice this. A case typically begins with the government formally charging a parent with abusing or neglecting his or her child, asking a judge to put the child in the government's custody. If they ain't trying to take you to court and prosecute you, they're full of bull crap. If they don't convict you and show that you did something wrong, they're full of bull crap, but they're threatening us these days, getting us to drop our kids off with them, talking about we're going to get arrested if we don't, and they're just private businesses, which goes against the Federal Debt Collections Practices Act. You cannot do that. Now watch this. In constitutional terms, the government must prove. How do you prove? Not by taking them to a CPS court. Excuse me for the sweat. Not by taking them to the CPS court and saying, we're going to say that you did something wrong, and therefore the agency is saying that we need to take your kid and keep your kid, and we need you to work with us and do services so we can make some money with our partners. So we're trying to find out if you did wrong or not. No, the freak, you're not. You're trying to find out how quickly you can rehome the kids, and after you rehome people's kids, you want to adopt. Shut the freak up. You're liars, okay? So what's happening is they have to prove you did something wrong. Watch this. In constitutional terms, the government must prove that the parent is unfit to justify changing custody. They can't just take your kid out your house with no warrant, with no court orders from an actual court of criminal jurisdiction that can throw your butt in jail. Watch this. The government, like any other party seeking to prove a case that it files, puts on witnesses and introduces evidence. They don't do that in that fake court. And this is why they're trying to trick us to believe we're in court with a judge in the front. Because their administrative hearing is acting like it's a legal process when it's not. Opposing parties cross-examines the government witnesses, challenges this evidence, and can put on their own case. That don't happen in our courtrooms with these fake courts. The judge considers the evidence presented, his or her state's substantive law, and relevant constitutional law. They don't let you use constitutional law in these Title IVe courts. They don't have jurisdiction to hear it. I keep telling y'all. Now I'm showing y'all. And then enters a ruling which parties may appeal. Okay? May appeal. Watch this. The judge considers the evidence. A ruling that parents have abused or neglected their children justifies a temporary remedy, typically placing a child in foster care. But when is somebody proving their case with the court of competent jurisdiction that could throw your butt in prison? Never. Their case, watch this. Parties seeking to terminate a parent's rights must prove their case by clear and convincing evidence. Guys, we are freaking being played. I showed y'all where, not me, but government committees, the bar, told in the 30s that this is what they were doing. Okay? Told what they were doing. People didn't want to hear me, but I'm showing you now what they're doing with their own documents. Their own documents. Now here's the thing, guys. I showed y'all before that common law is held outside. A court of record does not use the statutes. But they're having permanency hearings about our little ones. And watch